host and moderator of the session. If you have questions throughout the presentation, drop them in the Q&A rather than the comments section of the webinar, which I believe is actually disabled to direct you to the Q&A. And when we move through the content, I'll queue up the questions for our panelists and try to make it as interactive as possible. So now to introduce our panelists, today's session will be presented by Laura Lapsley, Jonathan Hromi, and Caitlyn Ward. Laura Lapsley is a senior intellectual property paralegal at MIT TLO, where she works with the life sciences licensing team. Laura has over 23 years of experience working with intellectual property at previous firms and organizations, including Analog Devices, Inc., WilmerHale, a startup pharmaceutical company, Fish and Richardson, and Cohen and Zucchero. Our second presenter, Jonathan Hromi, is Assistant Director at the TLO and heads up the intellectual property team. He is a strategy professional and registered patent attorney with over 10 years of experience working with Fortune 500 companies in developing and implementing IP and innovation programs and strategies. Our final presenter, Caitlyn Ward, is a senior licensing associate at the MIT TLO working on the physical sciences side of the licensing team. She studied physics and worked in a laser-cooled atoms lab at Creighton University. Following her studies at Creighton, she assessed and completed commercialization paths for patented lab-developed technologies while completing her master's in science entrepreneurship at the University of Notre Dame. So without further delay, I'll pass the ball to Laura. We can get started with the comment, and thanks again to everyone for joining.
Thank you, Kate. I appreciate that. Thank you, everybody, for taking the time out of your day to join in. As you can see here on our screen, we have a fiscal year 2021 fact sheet, and I'd just like to review some fiscal year 2021 statistics. Currently, the TLO has 54 full-time employees on staff. In fiscal year 2021, we invested $24 million in IP protection, and that's a reduction of $2 million from the prior year. So the TLO worked very hard on reducing costs in that field. We have 358 new US patents filed, 435 US issued patents. We have 421 international patents issued, over 3,500 active US patents, and our incoming material transfer agreements, almost 1,300. And our total licensing revenue was just over 87 million. We have a little bar chart here on the growth through fiscal year 2021. So 24 startup companies were launched. Our historical data was 528. We executed 103 license agreements, and we received 730 disclosures. Down below here is a pie, which is a nice image of our startup sectors. So 27% of our startups were hardware, 24% were therapeutics, 21% devices, diagnostics, research tools, 17% software, and 7% materials, and then we have other. So that's a nice little overview of the TLO. So I'm going to be discussing patents today at a very high level, different types of patents and the basic patent process at the TLO at MIT. So what is a patent? A patent is a grant by the government that allows you to exclude others from making, using, selling, offering for sale, or importing your invention, and that's for a period of 20 years. The US is now a first inventor to file country. So effective in 2012, the America Invents Act was transitioned to the US. That's also known as AIA. You may have heard of that acronym. And so this transition went from a first to invent system to a first inventor to file. So we'll discuss some types of US granted patent rights. We have utility patents, design patents, plant patents. So a utility patent can be a machine, a robot, motor, circuit, a process, So a method of manufacturing something, it can be an article of manufacture, for example, frying pan or hair comb, etc. Composition of matter, and that's a chemical compound. And the length of the patent term is 20 years from the filing date. The design patent is an ornamental design, so the appearance of something. And the patent length for that is 15 years from the date of grant. And we have the plant patent. So that's a new and distinct variety of plant that can be asexually reproduced. This does exclude tubers. And the length of the patent term is 20 years from the filing date. So let's start with a provisional application. A provisional application expires after 12 months, to which subsequent filings can claim priority. So an example of a subsequent application can be a non-provisional application, also known as a utility application, PCT application. The provisional establishes an early filing date for the subsequent filings. The strength of the provisional application does depend on the construction. So you can file a provisional cover sheet, which would identify the inventors, their residence, the title of the invention, the correspondence address, and any government interest, if that's applicable. Or you could file a full provisional application identifying the title of the invention, the background, a summary of the invention, any drawings, and a detailed description. Either way you file, you can obtain that filing date. A provisional is very limited in its use, so no formal examination takes place with the Patent Office, and no issuance takes place on a provisional application. So what is required to obtain a patent? The invention must be novel, useful, and non-obvious. So for novelty, the invention cannot have been disclosed in print, publication, public use, on sale, or otherwise available. Usefulness, the solution to a problem. And non-obvious, it cannot have been obvious to one skilled in the art. So requirements for patentability. Let's dig a little deeper into that. So novelty. For the US, there is a 1-year grace period after public disclosure by an inventor in which to file a patent. For the rest of the world, absolute novelty is required. You must file before first public disclosure, and oral disclosure does count. Making a note here about the grace period under the Paris Convention of 1883. So this is a treaty that establishes a right of priority, meaning an applicant can use their first filing date as an effective filing date in other countries, but the subsequent filing must occur within 1 year from the first filing. Once you have a US patent on file, it's okay to make public disclosure. So for usefulness, this is not usually very difficult to establish. Patent law provides a relatively broad definition of usefulness. Not obvious, that is subjective, and it can be difficult to establish. So a question to ask is, one, would one skilled in the field of the invention who has not seen the invention before find it obvious? Some other factors to consider: is the commercial success attributable to the inventive feature? Excuse me. Does it fill a long felt need? Is the invention doing what others said could not be done or would not work? I'm going to touch a little bit here on non-US patents. So, which I mentioned previously, the Paris Convention, the 12-month grace period is given following the US patent filing. It assumes novelty of the US. We have PCT applications, Patent Cooperation Treaty, we call those PCTs. It's an international patent law treaty which provides a unified procedure for filing patent applications to protect inventions in each of its contracting states. PCT covers most countries. I believe there are approximately 154 countries that participate in the PCT. Filing a PCT application buys you time, it delays expense, which allows more allows applicants more time to explore commerciality. It's used to manage risk. So for example, if an application, a PCT application is found to be unpatentable in view of prior art from the Patent Office, an early decision can be made to withdraw the application and avoid national filings from that PCT application and the high costs associated with those filings. A PCT application never issues into a granted patent. It simply expires, or you file nationally into other countries. So you have 30 months from the US filing date to file nationally. Most countries you have 30 months. I think there's about 66 countries. Some countries you can file at the 31-month date, perhaps in Europe, Korea, I think there's a few others. So these national filings, like I said, are very expensive. You have translations, they are very costly. You don't need translations for all countries, but most. And then, excuse me, we have annuities. So annuities are payments made to the various patent offices to maintain a granted patent. There's a lot of cost associated with these. So here at a high level, we have the patenting process at MIT. We start with the invention report, the technology disclosure form. This will document the date of the invention. This does not provide protection, patent protection. Then a literature and patent search is performed, typically by outside counsel. We call those prior art searches. Outside counsel will then prepare a patent application and file it with the patent office. The patent office eventually responds to this patent application filing with an office action, a first office action. It could take well over a year to receive the first office action, and it rejects most, if not all, of the claims. A reply is then prepared and sent to the patent office in response to the first office action. So there's back and forth between the patent office and the applicant arguments, if you will. Usually after these arguments have been set into motion, usually the patent office will then send a final office action which rejects only some of the claims. After all of this back and forth takes place, the patent is then allowed, and finally the patent is issued. Typically, issuance occurs about 3 years after the initial application was filed. The duration of the patent term is 20 years from the non-provisional application filed. There's no patent protection until a patent issues. Some important points regarding patent ownership. So a patent permits the owner to prohibit someone from using the invention without a license. A license will set the terms under which the licensee can practice the patented invention. The upfront fees, royalties on sales, the limitations, geography, duration, et cetera, will be negotiated. Having a patent doesn't necessarily allow the owner the right to use the invention. One reason for this is that the invention could be based on a concept which itself was patented by someone else. So the use of any invention may infringe on someone else's patent. So here's an example regarding an invention based on a concept by which itself was previously invented. We have the claim for a stool versus a chair. So for the stool, we have a piece of furniture intended to be used by a person sitting. It's comprising a horizontal platform, which is the seat, supported by 3 or more vertically disposed rods, which fix the platform at a height more than 12 inches, less than 30 inches above the horizontal surface parallel to the platform. So the rods, that would be the legs. So for the chair, we have that same piece of furniture intended to be used by a person. We have the horizontal platform, the seat, the disposed rods, the legs, but what is added is a vertical element attached to one side of the horizontal surface. So that would be the back, against which a seated person may place his or her back for comfort. So I thought that was a really good example. Here we have a little bit more on enforcement of infringement. So infringement is an unauthorized use of making, using, offering for sale, or importing. A patent owner can sue for an injunction, which is a court order to prevent future infringements. Can sue for damages, so money awarded. An ITC ban on imports. The ITC ban is where the International Trade Commission can stop the most valuable and widely sold products. And then we have defenses to infringements. And of course, that's that the entity does not infringe and or invalidate the patent. So some common defenses are the invalidity defense. So invalidating the owner's claims, citing prior art relating to the claim, among others. So that's where I am stopping. I know that Jonathan will be going a little bit more into infringement cases, but I see we have some questions here.
Yeah, I think one would be, this would be a good time to ask. So we have a question specific to the TLO on filing a provisional patent application. I'll pose this question to the whole group. How long does it usually take a provisional patent application to be filed by the Technology Licensing Office after a form is submitted?
That would be within a year period, but I think that really varies. And Jonathan, do you have more input on that as far as the office?
As far as the office, when we pick it up and when we would actually file provisional, yeah. I'll say it depends. And the reason it depends, and I know that's a lawyerly answer, and that's the answer to pretty much everything. But so actually, and this is a great question because it pulls in some of the concepts that Laura was talking about previously. So with the US being a first to file and the rest of the world being first to file, you need to get something down quickly, because everything that comes before you is prior art and could be used against you. Everything after you is no longer applicable, if you will. And so what happens is, to file a patent application, you need to have proved essentially reduction to practice, which essentially means you can describe how the invention works and somebody could build it. And that could either be you've actually physically built something, or you could actually have just described how it works to be able to allow somebody else to do it. So when we get a disclosure in, we're looking for those elements. We're looking to see, is it properly described? Is it something where it's reduced to practice? Is there enough here for us to actually file on? And so we'll go through the screening process and say, is there something here? Yes. You know, if it's fully described, we could file on it tomorrow or within a week, however long it takes to engage a law firm to be able to put together the correct formalities and then and then send it off to USPTO. If it needs more work or needs more description, then it may take a little bit more time. It may take, you know, it could take months to get a little bit more data or to get a little bit more structure around it. So the answer is it really depends, and it depends on what comes into us and how fleshed out it is and how far along it is for us to feel comfortable filing on it.
Thank you, Jonathan.
Yeah, thank you. So I think we can move on to the next section of the presentation.
Okay. Is that litigation?
Yep, I'm going to just, there you go. I've given you.
Perfect. So this is a really, the Kraft versus Kellogg example here is something that's going to bring together a lot of what Laura talked about in sort of the basics of patents. And I apologize that this isn't in person because usually we have samples for everybody. And that's something that you can all relate to is getting cookies while you listen to us talk. And it makes things a little bit better. But unfortunately, we can't send it out. So you're going to have to visualize some of this stuff. Now, the backstory of sort of cookie packaging, if you will, is that cookies used to, of course, come in a tin in the old days, then they'd come in sleeves. And then I don't know how many of you are old enough, but there used to be cookies in sort of cellophane packaging, and you'd open it up and then the cookies would go stale and you'd have to eat them really, really fast. And then when you get Oreos and you get 60 Oreos and they'd all go stale in 3 days and you're left with, you know, five great fresh Oreos that you ate and then 55 stale ones. And this was a bane of the industry for a while. And so what Kraft did is Kraft came up with a resealable pouch in around 2005. And what that resealable pouch is, and you can see it there on the screen, it's you've got a tab, you pull it back, and then when you're done, you can push it back down and it keeps the air out and it keeps cookies from getting stale. Now, as Laura talked about previously, you've got to have something that is novel and you've got to have something that's non-obvious. And Kraft met that standard and wound up getting a patent from the USPTO. And this concept here wound up, and the other thing that Laura pointed out as well is there are things called secondary factors when you're talking about obviousness. You're talking about things that point to it being more likely to be patentable than not. And those things are unmet customer need, you know, things that haven't happened before in the industry. And so when this happened, you know, Kraft wound up winning awards for this. Kraft wound up winning design awards. Their revenues shot up 4%. And for a national cookie sales, that's a lot of money. I think the last I had read about it was like $400 million or something ridiculous. It was a lot of money. And so of course, what's going to happen is that if it's making a lot of money and it's really desired by consumers, other people are going to copy it. And that's exactly what Kellogg did. Is Kellogg came around and said, all right, they've got this resealable pouch and this is really doing well. We're going to do the exact same thing. So they started packaging their pecan sandies in a similar design. And so again, as Laura pointed out, what a patent allows you to do is it allows you to exclude others from making or using. And then the only way to exclude others is to actually enforce the patent, which means to file a lawsuit and go to court. And so just as a little bit of background, going to court is not a trivial thing. It is, when you talk about patent matters, you're talking about somewhere around the realm of at minimum $250,000 for stuff that's less than $1 million at risk. For more than $25 million at risk, you're talking about somewhere around $2 to $4 million. You know, if you're going Apple versus Samsung, you're going in the tens or hundreds of millions of dollars. So this is not a trivial undertaking. Additionally, you're talking about years and years of litigation, because what happens in a patent suit is you essentially have two different trials. So as Laura had pointed out earlier, you've got the claims of a patent. And what the claim of a patent does is it sets out sort of the metes and bounds of what you're trying to claim as your invention. When she used the stool example and when she used the chair example, that's describing what those inventions actually are. And so I think in the next slide, we actually have the first claim here. And so what Kraft had set out was setting out what the, can you move to the next slide? Is that me or is that somebody else? Oh, I can control. Sorry. Laura, do you mind doing that for me? I'll continue talking. So what you have in a claim is setting out the metes and bounds of what the actual invention is. And so the first part of a patent trial is called the Markman hearing. And if there are any disputed claims or disputed terms in the claim, they then set out and say, what is this definition? So for example, in this, if there was a food container and food container didn't have an ordinary meaning, they would look to the specification of the patent. If it wasn't defined in the specification of the patent, they would then look and take on additional outside evidence and say, what is meant here by a food container? And so as you can see here in the claim, Kraft was claiming that their invention was a polygonal shaped food container, which has a frame, a wrapper, and a sealing layer. And then it further defines what a frame is, what's in that frame, which is essentially a hard frame that's allowed to contain food articles. A wrapper that goes around that frame that forms a top, a bottom, a side, and it allows you to sufficiently access that container. And then an adhesive sealing layer to then smack back on the frame and allow you to keep things fresh. So seems pretty standard now that we look at it, but it was revolutionary at the time. So now that they've defined what these elements are, now that they've defined what the definitions are, they then go and say, all right, does the product that you're alleging infringe meet and have all these elements? So in order to infringe a patent, you need to have a product that has at least all of these elements. And so when we looked at the Pecan Sandy container, they looked at it and they said, does this meet all, does it have the elements? Well, does it have a frame? Does it have a wrapper? And does it have a sealing layer? And does it do these things in the fashion that the Kraft patent describes? And the court heard evidence that said, yeah, you know what? Kellogg actually said that they developed a technology that maintains similar properties, but they intentionally copied Kellogg's patents or Kellogg's patented invention. And you would think that that was something that was a smoking gun and saying, yes, this is absolutely spot on. And the lesson here for this is that you can do everything right and still lose. The reason you can still lose is because if you go back to what Laura described as some of the defenses, is you're always going to claim that, one, I don't infringe, and then if I do infringe, it was obvious. And so what the court found here is that there were a couple references in the prior art, things that happened before Kraft had filed their patent that could be combined. And when they're combined, they combine it at a standard that they use to say it's a fazita, it's a person who has ordinary skill in the art. So if you can go to the next slide, please, I'd appreciate it. So in the concept of an invention, they always look at who is the person who is skilled. And here it would be a design engineer. And so what they wound up doing is they looked again at the art that was out there. And so they looked at a wet wipe dispenser and they said, oh, all right, what's in a wet wipe dispenser? Well, a wet wipe dispenser, you have objects there that are designed to be kept fresh because if they were exposed to air, they would dry out. It's a soft package, but it's got a resealable adhesive on it. And then you've got a cookie package and tray, and that's the old cookie package and tray, the one that didn't have the resealable feature. And so you've got a cookie package and tray that's there. It's got a wrapper. It's got a ability to keep air out until it's opened. But it's essentially the same form as what Kraft was using initially. And so they said, okay, if we take these two things, and then if you can go to the next slide, please. And we look at meat packaging, and this meat packaging was described in an article, in a 2001 article that was 4 years before the Kraft patent. They said, would somebody who is in the packaging engineering come to the conclusion to put these things together? And despite the fact that Kraft sales shot up 4%, despite the fact that nobody had done this before, despite the fact that Kraft had gotten a patent on this, they actually found the USPTO erred in issuing this patent, and it shouldn't have been issued because it was obvious to combine a solid frame or rigid frame cookie package with a wet wipe dispenser or a resealable meat container. And therefore Kellogg did not actually infringe. And so you can see it combines a lot of the things that Laura was talking about earlier about getting a patent of taking away and getting an early reference date, or an early filing date, so you can take out prior art. Because had this been filed years earlier, this no longer would have been prior art against it. Or taking along and making sure that things are non-obvious, things that are novel. So this is really sort of where you combine things. And again, it's also unfortunately a lesson of you can do everything right. The unmet demand could be there. And ultimately, you still have to go to court to make sure that your patent is valid. And of course, if Kraft had won this, they would have won millions of dollars in damages. And it was worth it for them to litigate it. It just turned out that it didn't turn out the way that they were hoping it would turn out. So I'll leave it there and see if there are any questions.
No questions directly related to infringement, so I think we'll save the ones in the chat for now till the end.
Thank you.
Give you control.
I got it. All right, so I'll be talking a little bit about MIT's policy toward patenting as well as the licensing process for patents. So our policy is that MIT owns intellectual property that's created on campus, except when it's not created under a sponsored research project, or it doesn't include significant use of MIT administered funds or MIT facilities. As Jonathan said earlier, when we say significant use, it can really depend on the situation. And so we do encourage our MIT inventors to disclose any invention to us, and we can make that significant use determination on a case-by-case basis. If invention was industrially sponsored, sponsors do have the right to request a license. Most often they'll request what's called a non-exclusive royalty-free license. And so this just allows them to operate commercially because we only grant internal use research licenses through their sponsored research agreements. So they do have to come to us for a separate commercial license, whether that be non-exclusive or if they elect a exclusive license, if that's available, which is royalty bearing. If an invention is government sponsored, and there are a lot of government sponsored inventions on campus, this includes any invention that might have DOE funding, NIH funding, NSF, DOD, as well as any invention that comes from MIT Lincoln Laboratory. MIT TLO does manage all of the intellectual property that is created at MIT Lincoln Lab, which is a federally funded Air Force R&D lab that's located about 15 miles north of campus. MIT is required to notify that government agency who was the sponsor of the invention that the invention has been disclosed to us, and then we have to elect title, which means that we have to file a patent application within 2 years of that disclosure coming to us. If we do choose to file a patent application, the government does get a royalty-free government use license. If not, MIT will waive any ownership rights back to that government entity. And I'll talk a little bit more about this last point here in terms of revenue distribution. But after we recover costs, MIT does take a 15% admin fee, and then we do distribute a lot of this revenue to the inventors and labs and centers and back into the institute. There we go. So the mission of the TLO is really to move innovation and discoveries from the lab to the marketplace. We do this by licensing our intellectual property to our sponsors who sponsor the research. We do this by licensing our inventions to startups that might have been co-founded by MIT PhD students or anyone who is a co-inventor on that invention. And we do this by strategically evaluating, protecting, and licensing our technology. And so we really are focused on moving those inventions to the public for the public use, and also being able to be part of this ecosystem to allow our professors and our students and other inventors to be as entrepreneurial and innovative as they can. So when we say strategically evaluate, again, our primary objective is to move our innovations from the lab to the marketplace. And so whenever we get an invention disclosure, we try to meet with the inventors to understand if they had any commercialization objectives with this. Again, if they might have a student that wants to do a startup, or if they think the sponsor might be really interested in this certain invention or intellectual property. Oftentimes we'll send out an invention to an attorney for a quick patentability review or prior art search. So again, like Laura said, we're looking at, is this useful? Is this not obvious? And is it actually something that we might be able to obtain a patent on? Sometimes we'll research the market and technology area, and the MIT TLO has a great intern team that we utilize for this. When we do determine the best path to achieve our primary objective of moving that technology from the lab to the marketplace, it might be through seeking patent protection, which is our main way of protecting intellectual property. Sometimes the work is published. And so like Jonathan said, if we know that there's going to be a public disclosure from a student or from another inventor, we do try to file a provisional patent ahead of that public disclosure to preserve our right to obtain a patent later. Sometimes we determine that maybe the invention isn't quite in a place for it to be patented. And so we might go back to the inventor team and ask them to maybe work on it a little bit further and further develop the invention to a point where we feel like we can obtain patent protection. We do open source a lot of our software. If an inventor comes to us and says that they feel like it's a software that should be open sourced, we always listen to that request, and we have an open source expert in our office who works with that, with those inventors. And sometimes if the TLO determines that an invention isn't something that MIT wants to pursue patent protection on, we do waive some inventions back to inventors. And so as Laura said at the beginning, the fiscal year 2021, we had 730 new invention disclosures come to the TLO, and this is a range of both patents and software disclosures. So when we protect our intellectual property, we do this mainly by seeking patent protection. And this is a little bit counterintuitive to the goal of an educational institution. So we, first and foremost, the TLO wants to enable and allow our professors and our students to do what they do, which is to teach and be collegial and to publish and present. However, patents are expensive and new technology development is very expensive. For example, it costs about $1 billion to develop a new drug, costs about $1.6 billion to develop new battery technologies. An MIT founded startup, Commonwealth Fusion Systems, just raised $1 billion for their nuclear fusion technology. So it takes a lot of money and a lot of time and effort to commercialize these technologies. And so we do seek patent protection because when there are investors that want to invest in companies that are founded on MIT intellectual property, they want to know that these startups have an asset in terms of a patent, as well as something that is novel and unique to that startup. So there is a lot of high risk in investing in any startup, but with that, there is a lot of high reward as well. And startups are risky. The majority of them fail. And so MIT wants to position itself to make sure that we can protect our intellectual property while also, again, allowing anyone who wants to found a startup based on MIT intellectual property the ability to do so by filing patents. And so as Laura mentioned in the beginning, in fiscal year 2021, we filed 358 new US patent applications. And we also had 435 patents issue, and 40% of those issued US patents are currently licensed. They are currently bringing in revenue and doing good for the public. So this is a nice quick overview of both our exclusive license company types and our non-exclusive company license types. Most often investors do want to invest in companies that have exclusive licenses. And so as you'll see, the majority of the exclusive license company types are those startups. This means that this company has the exclusive right, most often in a certain field of use, to use the technology and commercialize it. We do also license commercially to our sponsors if they elect that exclusive license, but more often they'll elect a non-exclusive license. When we say small versus large company type, a small company is any company that has less than 500 employees, larger than 500 employees. Small companies could also be any nonprofit. That's how we categorize them. So about a quarter of all exclusive license company types are small companies, and then large companies make up the rest. As you'll see with the non-exclusive license types, large companies do make up the majority of that. And again, when you have a larger company, a lot of times they'll take that non-exclusive because it might still be a market area that they are investigating. And so they might not yet be ready to take an exclusive license. About just over a third of non-exclusive license types go to small companies, and then the rest go to startups and sponsors. So how we craft our license agreements. So we at the TLO request a business plan from all of our interested licensees for a certain technology type, or maybe there are multiple patents or technologies that they're interested in. And we use this business plan to craft the license agreement based on maybe the business model, sales goals, who the team is, diligence milestones. When we receive that business plan and we feel comfortable that this particular licensee or potential licensee can commercialize the technology and has a plan to do so, we'll sometimes offer them a term sheet. Sometimes we'll just go straight to a draft license. It kind of depends. The term sheet mostly includes financial terms, so the royalty rate or any annual license maintenance fee or issue fee, if we're going to choose to take equity in the company or potentially change a control fee. And once those terms have been agreed upon, we will draft a license. We have a template boiler license that we use here at MIT. And again, we use that business plan to create a license that's unique to that potential licensee. This is where the negotiations happen. This often involves attorneys, so we rely on our Office of General Counsel to help us out if there are any questions involving the legal aspects of our licenses. Once everything has been negotiated, and these negotiations can take months, they can take weeks, it really does depend. As Jonathan said, it all depends on the situation that we have. We'll execute the license, and then we will maintain the license. Maintaining the license and following up with licensees, I would say, is a main job of a TLA, which is what Kate and I are. And so this includes following up on progress reports, following up on diligence milestones, royalty reports, just making sure that the licensee is in compliance with their agreement and that we at MIT know that they really are trying to commercialize the intellectual property that we have licensed to them. This might also include amending the license, and this has happened a lot because of COVID. There have been a lot of R&D delays and things like that. So if it comes to it, we will work with our companies to amend the licenses so that they are in compliance with them. If it does come to termination, we have mechanisms for that, both if it's a voluntary termination by MIT or the company, or if potentially the patents have expired and the license will then naturally expire. So in the fiscal year of 2021, we executed 103 new license agreements, and 24 of those were startup companies that were founded on MIT IP. There we are. Okay. So just some example elements of what can be found in our license agreements. We have a field of use. Sometimes this is all fields, sometimes this is field specific. This is super important as there are technologies in the MIT portfolio that are licensed to different companies exclusively, but in different fields of use. And so it's really important to define this term well, and that the licensee understands that they can only operate according to the field of use of their license. We do non-exclusive and exclusive licenses. We often include a license issue fee, royalty rates if it's a royalty-bearing license, sub-licensing. If that is part of the licensee's business model or business plan, we can include rights to sub-license. We have annual license maintenance fees. Sometimes MIT will take equity in a company as consideration for the license. This more often happens if it's a startup company, because a lot of times those companies don't have the cash up front. And it's also an opportunity for MIT to show that, you know, we are literally invested in the startups, and many of which are founded by former MIT students. Oftentimes there are milestone fees. So this means more often on the bio side, if a company achieves FDA approval, or if they've gone through a clinical trial or something like that. The thought behind it is when you do, you know, achieve a certification or an approval, your intellectual property or your product based on the MIT intellectual property becomes more valuable. And so we sometimes will have a milestone fee that essentially acknowledges that this product has now become more valuable. And so we will take a fee from that. We always ask for patent cost reimbursement. As Laura said, we've reduced our costs greatly in patent costs. And we also ask our licensees to reimburse MIT for any patent costs associated with the patents that are part of their license, and then those diligence requirements. We rely on our licensees in that business model to provide us with diligence requirements, and then we work with them to come to final requirements that, you know, might include a first commercial sale, sales goals, if they're going to test a product with a certain customer or in a certain market space. And so this just ensures that we know that they're working toward commercializing the MIT technology. And so in fiscal year 2021, MIT brought in $87.4 million in licensing income. And of this, $35.3 million was from an equity proceeds, equity revenue. There was also $13.8 million in patent reimbursements. So again, patents are expensive, especially foreign filings. So we do ask our licensees to reimburse those costs. Of the 519 active revenue generating licenses, 4 of those licenses generated over $2 million in revenue, and then 8 additional licenses generated over $500,000 in revenue. So where does this revenue go? The short answer is it goes back to the Institute. So after MIT TLO takes a 15% admin fee in consideration of managing the intellectual property as well as the amendments or agreements that go along with it, we then will reimburse all of our patent expenses, if there are any unreimbursed patent expenses. And then the remaining 85%, a third of that 85% goes to the inventors, a third goes to their department labs or centers, and a third just goes to the MIT Provost General Fund. And so also depending on the situation, we might have to share revenue with joint owners, foundations, and sponsors. But what I really want to stress here is that any revenue that's derived in excess of our costs does go back to the Institute and does go back to those people who invented the intellectual property, their departments, which will often fund their labs, as well as the Provost General Fund, which impacts the entire Institute as a whole. And so it's really great that not only is the technology doing good things for the public good in terms of being commercialized by our licensees, but any of that revenue that comes back to the Institute is also benefiting the Institute as well. And so in fiscal year 2021, we distributed almost $26 million to 1,291 inventors 89 department labs and centers, and 55 other entities, which is just quite awesome. So one of the departments, for example, that we will distribute revenue back to is Lincoln Lab. And so again, this is the federal lab that MIT manages the intellectual property for. And so they will do workshops like this girls engineering workshop. And so any of the revenue that comes back to them, they can put back into the community as well. So not only are the products and the services that come out of our intellectual property benefiting the community, but the revenue from that is also going back into benefiting the community and going toward events like workshops like this, or going into events where we can do outreach and get people excited about science and technology. So these are a few of the companies, just a few of the many companies that MIT licenses intellectual property to. Couple names on here that might be more recognizable, like Samsung, for example. The company Witricity has been a long-standing licensee of the TLO. They do wireless charging, and so they, license multiple patents from the TLO and are able to develop products for wirelessly charging vehicles, as well as consumer electronics and other devices. And so, these are products that people can go out and use and buy, and the revenue that they make from selling their products comes back to MIT. GelSite is another company that was founded off of MIT IP, so their foundational intellectual property is MIT IP, as well as it was co-founded by a former MIT student. And they've also been relatively long-standing licensee of the TLO, and are doing some really cool work with tools to look at surfaces using this technology called GelSite. So it's like a handheld camera where you can look at details of surfaces like coins, or they use it a lot on different vehicle types to look for imperfections in their manufactured pieces. So thank you so much for taking the time on this Friday afternoon to join us and listen to our presentation. I think I will turn it back over to Kate. I'll just put up our contact information here if there are any questions from the Q&A.
Thanks, Caitlin. Yeah, there are a couple questions, a couple as they pertain to licenses, then a couple that go back to kind of basics of patents. So I think I'll start with the few that are related to licensing. We have a question about upfront payments in a patent license from MIT. I know this is a challenging question to put kind of like a sticker price on, and I'm not sure it's really possible, but maybe just kind of explain how we approach financials of a license. And the question is specifically about upfront payments.
So like Jonathan said earlier, it depends. It depends on how many what we call cases or patents that we license to a company. It depends on the technology or the market that they are looking to develop. I would say on the bio side and on the physical sciences side, prices are very different in terms of what we ask for an upfront fee. It really depends on also how long it will take to get the product to market. So I can't really put like a dollar amount on what we put in our licenses, just because it really is very different depending on the situation. But what I will say is we do take a lot of what I just mentioned, a lot of different variables into account to ensure that what we do have in our license is, I don't want to say standard, but fair and consistent across not only the licenses that we do at MIT, but also tech transfer offices around the country.
Mm-hmm. Yeah, it is hard to kind of name anything because of the amount of variables there are, especially in the identities of people who are asking for a license and different rights that might appear in a license. But it is a good question, and thanks for explaining the approach, Caitlyn. A couple other really good questions about licenses, and one is about derivative IP. So who owns intellectual property that is derivative of that which is licensed?
It depends on who the inventor assigns to. So if a company licenses intellectual property from MIT, that is MIT solely owned. So that means that all of the inventors, because you have to have a physical person as an inventor on a patent, we have them assigned to MIT if they're an MIT professor or student, or paid by MIT, for example. If a company licenses intellectual property and say people solely from the company develop IP based on that, then the company would own that intellectual property. However, and Jonathan, you can jump in on that. There might be background IP that they might have licensed, and so they would need that background intellectual property from MIT in order to have freedom to operate. If a company sponsored research in a lab and there was a company employee in a lab at MIT and an MIT professor and a company employee jointly developed an invention, then it would be jointly owned, at which point the company could license MIT's exclusive rights to that invention. But it all really depends on the situation, the inventorship, and who is actually determined to be an inventor and where that intellectual property was developed.
Yeah, I think your comment on background IP is a great one and something for the audience to sort of consider. When new intellectual property is created related to previous, the patent that's granted still stands. And so you may need access to the original patent to practice legally whatever else has been generated. So that was a great point, great explanation. Thanks, Caitlyn. Have one more for you, sort of in the arena of licenses. So the question is, if an exclusive license is granted to a company, can MIT continue to do research related to that IP that has been granted under the license?
Yes. So MIT does reserve the right to practice the invention for internal research and educational purposes. We actually reserve the right for all nonprofit institutions to do so in our license. And that's something that's standard because, again, we do want to allow our inventors and our students to continue to be professors and students and publish and present. This does create a lot of discussion around who we license to, and if the professor is going to continue to do research in that area that the technology is in. Sometimes we do have to preserve rights for future sponsors of a professor's work. So if the professor is working on battery technologies and they've disclosed an invention to us and we've licensed that, sometimes we will reserve the right in the license to future sponsors of the professor's lab so that so that a company can have the current invention as background intellectual property and there's freedom to operate. So MIT does work very closely with our professors to ensure that they can still do research in their lab if the technology is a research area of interest to them in the future.
Great. Thank you. So I'm going to kind of flip back to now the questions related to patents arena. So we had a question, Jonathan, sort of related to what you were explaining about reduction to practice, but the question was asked directly. An attendee, if they have an idea about an invention that can be made, but it's just an idea, haven't started creating it or working on it, can it be patented?
Yeah, thanks, Kate. Again, that goes back to straight up no. Because you have to be able to fully describe it. Again, it needs to be in a form of what we consider to be or call reduction to practice. And that reduction to practice could be either you physically built it, which is actual reduction of practice. So you've built the widget or you've built whatever it is that you're trying to patent, or it could be constructively reduced to practice. And what constructive reduction to practice means is that you can describe it in a way that someone else who, again, going back to the Fizita standard, the person having ordinary skill in the art, can reproduce it. And what that means is if it's a physics invention at a nuclear physicist, that the average nuclear physicist can pick this up and reproduce it. If it's a consumer goods, the average consumer goods designer can pick it up and reproduce it. So the standard changes based on the invention, but it's always the same standard of the average person in this field having that skill can look at this and reproduce it. Let me give you an example of a famous case of an idea that's reduced, or an invention that's reduced to practice without actually building it. And that was one with an electrical circuit. And so somebody wound up sketching out on a napkin a novel electrical circuit, put it down, wrote it down, and that was sufficiently enough reduced to practice because any engineer picking that up could read that diagram and then say, oh, you know what? I can build this. And so that's what we talk about when we talk about constructive versus actual, but an idea alone is not sufficient. You have to do the extra step.
Thanks, Jonathan. We have another question related to open source. So I'll kind of pose it to the whole panel. The question is, can you patent an open source device and will you have to declare it in the license? So I think a helpful way to maybe answer this question for the audience would just be about sort of copyright and patents and maybe how we think about code as an invention, whether it's artificial intelligence or sort of a method of doing something, but how we would think about a patent for something like that.
Sure. I mean, I'm happy to start, and I'd appreciate it if other people can jump in because open source isn't exactly my forte. However, yes, you can absolutely patent if it meets the patentability criteria of new, novel, and non-obvious. You can absolutely patent software. You can absolutely patent open source. What open source does is open source is what sort of came before, and you're taking something subject to the terms and conditions of that license. And so Caitlyn can talk a little bit more about that. When it comes to software in general, software is typically copyrighted and it attaches automatically. Now, when you talk about when you talk about patenting software or patenting a device to run software, again, has to meet the criteria of patentability, but you also have some additional hurdles, if you will, in the patent world when it comes to software, AI, et cetera. There was a series of cases called KSR, Alice, where they were talking about in the background, there was a time and a period in US patent law where you could put anything on a computer and get it patented. And so what the law did is the law swung back to say, all right, we're gonna not allow just you to say, all right, put it on a computer, and we're now allowing you to patent normal, conventional things. A good example of this is the Amazon one-click, where you could do sales in a store, you would then go buy it. Well, now you move it online and Amazon patented what's called one-click, where you click it once and you're allowed to then buy it. And the court said, yeah, things like this are getting a little too out of hand. So they started to dial that back and put a higher bar for patenting software. So it's got to go through an Alice test where it's got to be a claim, it's got to be a process, a machine, a manufacturer, and then it's got to go to a judicial exception. And that raises the standard. Those judicial exceptions are sort of carved out in case law, and they're really more about transforming the data and putting it into something that is going to be a little bit more productive, or does it come out to something that is commercially viable? It's a higher bar. We can go into it a little bit further if you want, but I'll just leave it there and say it's possible, but it's difficult.
I'll just add, I'm not the open source expert in the office. However, when we do get an open source request, we always honor that from the inventors, and Aidan Fowler, who is the open source person at the TLO, he pretty much makes sure that whatever license the inventors want to release their software under is just compatible with MIT's policies on releasing open source software. I'm not exactly sure which licenses those are, but I would reach out to him or disclose your invention if you have any specific questions about open source.
Great, thanks, Jonathan and Caitlin. So we have a specific question about equity-only licensing for artificial intelligence related intellectual property. The question is, what exactly is involved in this type of license? I don't think anyone on this panel or myself is kind of our in-house expert on AI patenting licensing, but I think your question related to what is involved with an equity-only license could be maybe explained by Caitlin.
I have never done an equity-only license. I'm sure this is very situation specific in terms of maybe the product or service that this company was offering. So maybe they aren't going to be generating revenue right off the bat. And so the way for MIT to receive consideration through their license was to take equity in the company. I think that's all I'm going to say about that. I feel like it's probably just a very situation specific license. I'm not sure if there's anything specifically related to AI that the TLO did the license in that way.
Yeah, I think as kind of mentioned in the question, Dan Dardani would be sort of the best person to explain what kinds of situations it's appropriate in. I also have never been involved in that sort of style of a license, but exactly what Caitlin said, if the situation was appropriate, then equity would be the main form of consideration or financials contained in that type of license. So we have one more question, and pose it to the group, maybe more related to sort of patents, but the question is, can anyone file or anyone in the US file, or do they need to be a US citizen? Or excuse me, I'll just say, can anyone file as an inventor in the US?
So yes, anybody can file in the US if you have something that meets the statutory criteria for eligibility. To touch on something that Caitlin had talked about before when she was talking about licensing is, when you're thinking about filing, you have to understand, do you actually own the invention that you're filing on? So people that are from MIT, and we've got our policy, there are certain things that we may own things if you use substantial resources, or your employer may own it. The other thing I would encourage you to look at as well is, if you are a foreign national and you are thinking of filing in the US, look first to see what your local laws are. So for example, I know that Indian citizens, if they are an Indian citizen, they could file in the US, but if the invention was made primarily in India, you need to get a foreign filing license first. Same thing for if you're a US citizen and you're looking for, to actually protect rights in the US, if you file in a foreign country first, you may, and it has, first of all, if it has federal funding, then you run afoul of the law. And then secondly, if you do apply foreign and you apply it first without getting a foreign filing license, you may lose the rights to patent in the US. So you really need to understand, if you're a foreign national, if your actual country has laws that would prevent you from filing in that country first, or whether you should file in that country first.
Thanks, Jonathan. And that concludes our Q&A list of questions in the chat. So with that, I think we're going to kind of bring this session to a close. Say a final thank you for everyone who came out and participated in the session today. And I've dropped a link in the chat to other IAP sessions hosted by MIT TLO that are coming up in the coming weeks. So thanks again, and everyone is free to sign off. And thank you to our panelists. Great presentation.
Thank you, Kate.
Thank you, Kate.
Thanks, Kate.